Greetings from Chicago, and thank you all for joining us in this room and online. I'm Guy Rolnick, professor of strategic management at the University of Chicago Booth School of Business, and the one of the organizer of this conference. Today, I'm happy to introduce a conversation with Roger Alford and Doha Meki, moderated by Josh Cisco. Before we begin, please note we are on the record and live streaming, and we will post all conference videos on the Stigler YouTube channel. As usual, views expressed by guests are their own, not those of the Stigler Center or the University of Chicago. We hope that you will join us for the remainder of the conference today on the live stream, as well as for more upcoming events. So please check out the Stigler Center website, as well as its publication, promarket.org, and Capitalism podcast. And now, please allow me to briefly introduce our speakers. Roger Alford is the Principal Deputy Assistant Attorney General for Antitrust at the U.S. Department of Justice. He previously served in the first Trump administration as Deputy Assistant Attorney General for Antitrust. Prior to returning to the DOJ, he was a member of the Notre Dame Law faculty for nearly 13 years. During that time, he also consulted on antitrust matters, including as an expert witness in the landmark 2023 litigation against the National Association of Realtors and consulting for Texas AG Ken Paxton in Texas versus Google. He previously clerked for several judges and practiced law in D.C. Doha Meki is a senior fellow at the Berkeley Center for Consumer Law and Economic Justice. Previously, she served in multiple senior roles at the DOJ over 10 years, including as the Principal Deputy Assistant Attorney General and Acting Assistant Attorney General for the Antitrust Division. Before the DOJ, she was an associate in the Antitrust and Financial Services groups of an international law firm in New York. Our moderator today is Josh Cisco, who is an antitrust reporter at Bloomberg. He follows civil and criminal antitrust litigation and government investigation with a focus on live court coverage and analysis, reporting on competition policy as it relates to Silicon Valley and the broader tech industry. Thank you all for being here and making the time. And now I turn it over to our speakers.
Hi, well, thanks so much for having us. I guess I wanted to just start off with, we're about it's not even in the first 100 days. We're still in the first 100 days. And you guys have been in the building for about 5 or 6 weeks. So I wanted to turn it over to Roger just for a couple minutes to sort of give the lay of the land, how you guys are thinking about your approach to enforcement and policy, and then we'll take it from there.
Thank you. Thank you, Josh, and thank you, Doha, for the opportunity to be here, and Guy Rolnick for inviting me to be here. And I should say that Guy invited me to give a speech here when Gail regretfully declined to be able to attend. And I said, I'm not giving a speech before Gail gives a speech. Like, she's going to be the first person to give the speech before I am. So you were very accommodating and had this fireside approach. So Gail Slater is the AAG for antitrust, and I think is a very hopeful sign about the future of where we're headed with antitrust. And I know all of you are trying to read the tea leaves about, the direction that we're headed, and there's only a few data points that you can really rely on, but I would encourage you to look at her Senate Judiciary testimony, her QFERs in response to questions from the Senate, her fireside chats. I think she did 3 fireside chats last week. And then also some of the initial impressions from the early cases on mergers and on conduct cases, and statements of interest and oral arguments that have been done in those statements of interest. And then, of course, coming up very, very soon, the hearing in Google search remedies. And so I think those are all very useful indicators of the direction that she's going. And I think that's the sort of slogan that you hear a lot from her is vigorous and fair antitrust enforcement with clear rules. That's really what I think her goal is. And the other thing I would really emphasize is her very strong desire to make sure that antitrust is serving the needs of the average American worker. As I said in my Senate judiciary testimony on December 17th, and also I testified in November in the Senate Judiciary Committee on the credit card proposal by Senator Durbin, there is essentially a realignment that's happening in the Republican Party, in which there's a very significant push toward economic populism and the desire to be populist in the way that we do antitrust enforcement. And that's reflected in the choice of Gail Slater. And also that's selected in the choice by President Trump of J.D. Vance. And so I think that that's what you should expect, that there's a desire to make sure that antitrust works for the average American person. And one of the things that really means very significantly is look at the things that matter most to the average American, and are those markets competitive? Housing, healthcare, transportation, entertainment, food, groceries, entertainment. I mean, there's so many different areas that you think of, like, what does the average American spend their money on? We need to make sure that those markets are competitive, and it's very clear that many of them are not. Fortunately, a lot of those exact core pocketbook issues have been addressed in recent years, and we really are in an incredibly amazing time in antitrust enforcement. When I was starting in 2017, we were like, gosh, look at all the things that the Europeans are doing. Maybe we should do some of that, you know? And I would travel the world, and the question was, well, where are the Americans? You know, why aren't the Americans more involved in this kind of stuff? And so, you know, it is really quite remarkable how much was accomplished in the first Trump administration to show clear signals of desires for more aggressive antitrust enforcement. You know, labor markets and no poach, for example, a vertical merger case that was the first in the door when the first day making Del Rahim started at the Trump administration. And you could say we lost the battle but won the war on vertical mergers because of the fact that it was acceptable to challenge vertical mergers either for foreclosure reasons or for raising rivals' costs. And we've seen a renaissance of challenges to vertical mergers. And then, of course, most importantly of all, you know, the desire to really take seriously the monopoly conduct of companies, and both at the FTC with Facebook and with the Google case in 2020, those are signals of a genuine bipartisan interest. And it is in everyone's interest in all parties that we reflect a shared commitment to address conduct abuses, cartel behavior, and monopoly abuse. And so I think that's where we're headed in the future. And I also sort of had some influence on where Gail Slater's first speech would be. And I said, you can't speak at the University of Chicago when just an hour and a half away, you know, is the great University of Notre Dame. And so her first speech is going to be at Notre Dame on April 28th. And the title of the speech is "The Conservative Case for Vigorous Antitrust Enforcement" on April 28th.
All right. Thanks, Roger. So I guess to go from there, I mean, you were in the first Trump administration with Doha, and then you continued that into Biden. And so there's been this kind of through line. There's been a lot discussed about this sort of new consensus about populism and competition policy. And I'm wondering, like, if you guys could speak just sort of briefly about how things have kind of how it's shaken out, and you know, what continuity there is between the administrations, and how things are different, particularly between the first Trump administration and now, even though, you know, there's limited data points so far here. But yeah, how has it changed? How is it the same?
Do you want to start?
Go ahead.
So
You've seen all three.
I had the great privilege of serving as counsel to Tameka Del Rahim when I was a career public servant at the DOJ. And so I saw firsthand the AT&T Time Warner merger challenge. I saw the filing of the Visa Plaid merger challenge, the inquiry into the market power of dominant internet platforms, which was really a project of then Attorney General Bill Barr and his deputy Jeff Rosen, and of course the filing of the Google search case, as well as the indictment of the first labor market conspiracy cases that we could find in the history of the Antitrust Division. And it was really a privilege to have all of those things in my portfolio when I was working there at the time. And so I think that this break from Republican orthodoxy really shouldn't be missed. There are a lot of ways in which you might look at other enforcement metrics and take issue with how pro-enforcement it was, but I can't say enough, especially now that I am not in government and don't have the same constraints as my friend Roger. It's really hard to do things differently. These public roles are very high pressure, and doing the things that matter when it's hard, that's exactly what we want public officials to do. And I think there were real elements of that in the first Trump administration. And so when I came back as principal deputy under Jonathan Cantor, and then ultimately helping to quarterback the Google search trial, the JetBlue Spirit filing and trial, and other examples of enforcement, the Visa case, the Live Nation monopolization case, and others, we felt like we had a platform to run and to take on the biggest, most intractable problems, because fundamentally the role of the Justice Department is to take on the biggest, most intractable fights. And so when you're talking about trillion-dollar companies, right, the average person can't vindicate their economic liberty, right? Like they can't take on those fights. And so that is a proper role for the DOJ. I should also say that because Macon was willing to embrace really a policy that came down at the end of the Obama administration about concern for labor, trying to proffer explanations for why there was a two-tiered recovery from the financial crisis, why there was reduced labor dynamism, why there was reduced business dynamism, why markups had increased, why more industries were concentrated over the last 40 to 50 years. A lot of those recommendations, particularly around no-poach agreements, were ultimately embraced by the first Trump administration, at least in the Antitrust Division. And so we were able to come in and indict more labor market conspiracies. We were able to focus on worker misclassification. We were able to focus on amicus briefs that really set the law in the right direction. And so to me, I think the nub of consensus, such as it is twofold. First, it's reverence for law, right? Like this is a fundamentally conservative principle, right? Like it's often conservatives traditionally who've told us concern for rule of law, textual approaches to law. That is very important, and I think that was something that we tried to champion when we were in office. The second thing is that we focused on market realities. Right. And so what is breaking like with orthodoxy really, like when like the rubber meets the road, it's accepting markets as they are. It's shedding the ridiculousness that like vertical math can tell you something about whether, non-horizontal mergers or platform mergers actually are harmful to competition. And so making sure that we're learning the most that we can about these big, difficult problems, healthcare, agriculture, labor, tech, and more, was really very important. And I will acknowledge my hubris. I think that the Trump 47 folks have a real baton that they're taking. And I think ultimately it'll be their choice, sort of how they make use of it. But I think they're not starting from greenfield here. So if the president is taken at his word that he's concerned about big tech monopolies and other kinds of monopolies that are really immiserating the American people, it's really the DOJ Antitrust Division that has a big platform to run.
Yeah, I would say that the first Trump administration handed the Biden administration a very light and easy baton to seize. And then now we have a very heavy and full baton that we are seizing. Like there's so many cases right now. And it's really quite remarkable. What a great time to come in and the 2 weeks later, 2 weeks in, a month in, you get to do remedies, Google remedies. That's an amazing opportunity. And then one can assume in the coming years, not just at the trial level, but appellate and the Supreme Court level, on some of these cases. Isn't it strange though that we've been talking about Microsoft for 50 years? Like, how long can we? I mean, when are we going to stop talking about Microsoft and talking about the next Supreme Court? And that's a DC Circuit case. We only got a Supreme Court case. We have Microsoft. So it's exciting to think about where we might be in 2 or 3 years in terms of clarity on some of these laws. Yeah, I would agree and echo what you're saying. I think Obama administration, October 2016, announced the No Poach initiative, and Makan Delrahim's efforts were really on no poach, but really only no poach. And the Biden administration focused, I think, on other labor issues. I think that's certainly notable on merger reviews. Kroger, Albertsons, and Penguin. There are various examples of that. And now there's more merger cases that have labor issues. And then the other interesting thing is monopsony power in labor markets. That's another new, really interesting thing. And obviously that's something that I think is percolating up and will be an area of genuine interest. And the other thing I think, quite honestly, there's a lot of new emerging issues that are incredibly interesting. We were talking about tacit collusion 5 years ago, but now we have genuine, actual cases involving algorithmic collusion. Real cases with opportunities for real case law on algorithmic collusion. And then we have academic articles suggesting that the next big risk is autonomous algorithmic collusion. Basically robots acting like, parties in a room, and how they would maximize profits. If you just tell a robot to maximize profits, they'll autonomously lead to cartel-like pricing behavior. So that's, very, very a cause of great concern. And so I think there's a lot of real interest in the monopoly cases. I think that the number of cases, the only downside of all of the cases that you guys gave us, it's going to take just a year just to get through all of those cases before we can even start thinking about a lot of really new other cases that we want to bring. There's just so many cases that one would want to bring. And I think, am I right that this is the same problem you had? You would get a menu of options of things like, these are all the problems that you're seeing in all the different markets, and which ones should we prioritize? And you're literally making choices about incredibly hard, it's just so many different cases you could bring, and then what has the biggest impact on the greatest number of people. And so I think that's sort of the dilemma that we're in. There's so much bad behavior out there in the market that needs to be addressed.
The PDAG in me sees the PDAG in you.
Josh was going to interest us that I'm Doha 2, and I said, well, we have Terminator 1 and Terminator 2. I could say that.
I can't miss an opportunity to say this is exactly why Congress should restore the antitrust division's merger filing fees, which have funded the antitrust division for decades. It is also an important opportunity for me to tell you what I spent many years telling Congress, which is that for every dollar the Congress appropriates to the antitrust division, the U.S. economy gets $11 back. And I'd like to point out you
need that, Larry.
Yeah, that's good. The other thing you should know is that the antitrust division had DOJ before there was DOJ. There's a procurement collusion strike force that at this point has indicted for felony violations of Title 18 and Title 15, which is where the antitrust laws live, just on procurement contracts with the federal government. Everything from scams affecting the intelligence community, the defense community, agriculture. I mean, they really run the gamut. And so they have already been going after waste, fraud, and abuse and returning hundreds of millions of dollars back to the federal coffers. And so I just think the value of the antitrust division is plain. And now in a position where the Republican Party has total control of the federal government, there's no time like the present to fund the antitrust division, right? You can't police a multi-trillion-dollar economy with $233 million of fees.
Right.
I wanted to go to the bipartisan sort of consensus on this issue just briefly again. And Mark Metter, the third Republican on the FTC, was just confirmed yesterday. Party line vote, I think it was 50 to 46. And I'm wondering if, historically, antitrust was not, and competition policy was not a political issue, but it has been, and it has become much more political in the last over the last several administrations. And do you think that that is going to make it more difficult to have this sort of consensus across party lines on economic populism? Just whether or not it's a policy disagreement or whether it just is a political disagreement that is going to get in the way.
You mean because of what happened at the FTC?
Because of what happened at the FTC, because of what is like happening across the federal government, there's just much more sort of overarching concern about political interference. And I'm wondering if that is going to make this sort of cooperation more difficult.
Well, I mean, we all know, and we all are watching, different actors that are in the crosshairs trying to see what they can do to find soft spots in the administration. And so obviously everyone is aware of that and that is happening. And so what I would recommend that you do is just watch and see what happens in the coming, 2 to 3 months. Are those efforts getting any traction or not?
Efforts to lobby
or to modify after a weekend or to settle or whatever, like all those cases getting any traction. So I think, I would just say, let's see where we are in 2 or 3 months. I think a fair-minded interpretation of what happened with the FTC is that this just is a reflection of the administration's views on independent agencies. And the fact that it was not the first, it was like the third or fourth or whatever of the independent agencies suggests to me that this is really a bigger constitutional, it truly, I think, is a bigger constitutional question. It's not about competition.
I think competition policy is a very small and often happy place for bipartisan interest to live. But obviously, the Congress, the American people are thinking about all politics, right? And not thinking about competition in a vacuum. And I think that what makes the decision to try to remove Becca Slaughter and Alvaro Bedoya from the FTC so problematic is that even if you take the administration at its word that it was seeking to just launch like a facial assault on Humphrey's executor, the independence of agencies, attempting to remove the 2 Democratic commissioners is an odd choice, right? So if someone was really focused on this, you might have removed a Republican and a Democrat, or attempted to, right? That's setting aside whether it is a good idea to try to make a frontal challenge to independent agencies, right? Independence doesn't actually mean independence. In the FTC's case, it just means for cause. They're still subject to oversight. They're still sort of receiving the policy priorities of the president and so forth. And so I think all of this becomes very fraught. Last week, I was at a really wonderful gathering in Washington put on by Y Combinator. And it was really an interesting opportunity to hear from folks on the left and on the right. And I would just note that in my fireside, Mike Davis, who's very much a conservative legal movement firebrand, said it was his opinion that it was very stupid to try to attempt to remove them, and that if you were trying to conceive of all of the ways that you could really do nice things for monopolies, that seems like one.
So on that topic, is sort of adjacent to that topic, there is this, it's been reported over the last few weeks, there's a major DOJ restructuring underway. There's the proposals affecting antitrust in particular are to close 2 of the field offices, fold in the economists into other sort of department-wide offices, and a couple other things. I mean, how that hasn't been finalized, but how is that unfolding internally at the antitrust division? And I mean, the San Francisco office in particular is where much of the tech cases have come out of. I mean, including Apple. I think that office led the Apple investigation. So closing those offices and some of this other restructuring is sort of at odds with the stated priorities of being aggressive against tech and other sectors. So how do you see that unfolding?
Right. So yeah, that's a great question. And I will say several things. One, the big picture idea of having government be more efficient and eliminate waste, fraud, and abuse is a laudable goal. it's a goal that has been pursued by previous administrations. The other really successful example, of course, is the Peace Dividend Initiative by the Clinton administration, where they tried to really significantly reduce the size of the government. So one obviously can have a whole variety of different viewpoints about the manner in which that is being effectuated in the current administration, but the goal of more efficiency and eliminating waste, fraud, and abuse is a good one. But to your point, the Department of Justice is an absolutely critical goal, critical agency for trying to effectuate the goals of the administration, including the goals with respect to antitrust. And everyone knows that the antitrust priorities are very, very significant. I think just the way that Gail Slater was announced in her nomination so early and so strongly reflects a pretty good idea about where the administration's position is on antitrust. And we are aligned, I think, with the career staff, career attorneys, everyone at the Department of Justice in terms of like the desire to make sure that there's vigorous and effective antitrust enforcement. And so it's really a twofold fight right now, Josh, and that is trying to make sure we can be as effective as you can in keeping the budget. You mentioned the $233 million budget that was your last year, right? It was $233 million. At a bare minimum, keeping that number, and then also trying to recapture the the merger filing fee funds that are supposed to be earmarked for the Department of Justice. If we can win that battle, then all of the concerns about making sure we're living within our means, I think, are reduced. And then the other issue, of course, is just reorganization questions. Reorganizations for the sake of reorganization means that we just have to make strong arguments about why this proposal is a bad idea or that proposed idea is more plausible, and also to suggest alternatives. I mean, thankfully, the reorg memo from the ODAG very clearly said this is a proposal. We want input from all of the relevant units within the Department of Justice, and we have provided that in executive summary, in detailed summary, in meetings, in phone calls. So, I do think that it's extremely helpful to have Gail Slater in the position that she's in, because she has the trust of leadership within the Justice Department and within the White House. And the fact that there is trust means that if she recommends this path instead of that path, I think it will go a long way. So, to be determined, right? To be seen, but I do think that we're making good progress in our responses to the reorg memo.
We only have a few minutes left, but one thing I wanted to kind of get into was non-tech enforcement. I mean, there's so much that has been talked. Everybody wants to talk about tech and the antitrust cases against the biggest tech companies, and I think that is what has amplified this issue so much over the last 6 years, is the focus on Google and Amazon and Facebook and Apple, etc. And but like you were saying at the beginning, this focus on the average American worker, I think it's certainly debatable that some of the tech issues, while important, don't capture like the average American's attention as much as like the price of food or the price of healthcare or the price of housing or anything along those lines. And so given that there is already, I think there's lawsuits against most of the major tech companies, and with like a couple exceptions, do you think that the focus is going on the investigative side is going to move away from tech and towards some of those other sort of kitchen table issues?
When you say move away, I don't interpret your question to mean try to resolve the existing cases. So like if we had more attorney time and more money, and as we're entertaining new conduct cases, what kind of things would we focus on? I would encourage you to look at her fireside chat comments. She talks about consumer-facing concerns, and public-facing issues, and the desire to try to make sure that we're helping the average American. And so I do think that is front of mind in the focus that we will have. But there's a lot of incredibly difficult work in that space. I mean, just alone looking at the healthcare market, for example, just the healthcare market, you can imagine a half dozen different major problems, right? And so She said this publicly, so I'll give you a little anecdote, and that is like in the conference room where the DAGs meet, with Gail, we on the big bulletin board, the quote that she has is "Keep the main thing the main thing," and I think that that's just an admonition to make sure that we're like really remain laser focused on what the average American that supported this administration really cares about, and we know that inflation and the cost of goods and services is a significant part of that. So the answer to your question is yes to the premise. Yep.
I'm gonna switch gears just really quickly, just given I am not a trade expert by any means, but given everything that's been in the news in the last several weeks, like how does that intersect with competition policy? It seems like it would tee up concerns of collusion, like trade, increased prices from tariffs is like I don't know, but cover for collusion in the way that inflation has been talked about by some. Like, how are you guys thinking about that?
I don't want you want to, I can say what I can say and then you can say more. So basically, I actually got the same question at Capitol Forum last week. And I just like in the last administration, inflation gave companies cover to do things that were really harmful to the American society and the American workers and consumers. I think that tariff increases give people cover, opportunities to consider engaging in really harmful conduct. And so dynamic pricing behavior is a polite word for it, but essentially, like, we can imagine that they will take action, especially if they see a market that used to have 5 competitors now has 4 competitors because the tariff rates are so high that it essentially forecloses the market. I teach international trade in addition to antitrust, and I see what happens when anti-dumping duties are imposed at 100% levels. You see what happens to the market. And they're essentially like closed out of the market completely. If 100% duty is imposed, anti-dumping duty is imposed, it's essentially closing them out of the market altogether. So that also might impact merger review analysis, in terms of like who the players are. If there's a merger in the context of a situation where an actor that was in the market is essentially foreclosed. So I think that there absolutely are issues related to trade that are going to be relevant, both with respect to collusion and with respect to market analysis.
So, as Roger predicted, I can say more. Um, I think that antitrust and trade have always moved together, right? And it's really a three-legged stool. There's antitrust, there's trade, and there's industrial policy. And so Roger is exactly right that merger review probably should take into account not just the tariff regime, but the arguments that companies with market power often make to commerce about the imposition of tariffs and how they sometimes can weaponize a tariff regime to boost market power. But I think there's to zoom out, there's a broader macro point, which is that, I'm still a little bit seasick after watching what happened to markets over the last week or so. I think the American economy has plenty of challenges, like addressable challenges, no doubt, but the US economy is the envy of the world. I mean, it is a wonderful, extraordinary thing. American ingenuity is a wonderful, extraordinary thing. And I think the decision to go sort of headlong into, you know, an uncertain and extreme tariff regime. I know there's all sorts of like retrofitted explanations about whether this was a master plan or not. It did not strike me as a master plan. There's nothing wrong with a sort of a thoughtful approach, but to go all in on tariffs and not consider expanding the U.S. industrial capacity and a lot of the industries that were affected struck me as bad policy. Again, there are geopolitical ramifications. You know, driving Europe into the arms of China strikes me as a terrible consequence of these kinds of policies. And so I have to go on faith that people who think about tariffs full time, people who think about industrial policy, like I'm an antitrust lawyer. I know how to do one thing. I hope that people are thinking about all of these policy adjacencies together, because something very catastrophic will come of not thinking about the three-legged stool.
So one data point that's worth interesting is the Whirlpool and the tariffs on washers in the first Trump administration. Whirlpool merged with Maytag like 10 years before that and argued that there was vigorous competition because of LG, and then 10 years later they're asking for essentially safeguard tariffs on LG products. And then after the tariffs were imposed against LG, two things happened. Whirlpool raised their prices, not just on washers, but also on dryers. And LG rushed their construction of their factory in the United States to try to restore competition. So all of those dynamics, I think, could play out in a bunch of different markets if these tariffs happen.
I think we're out of time. But do you want to any final comments?
I don't know. Roger, do you have final comments?
You started enough.
Okay. Look, I think this is a really exciting time. You know, the Trump 47 folks are not even at the end of their first 100 days. And so there's a lot of distance to cover in terms of like where we're going in competition policy. But I want to revisit a question that I didn't get a chance to respond to earlier, which is about the impact of some of the office closures and the Deputy Attorney General's memo. You know, I saw the copy of that memo that wound up in the New York Times. And my first reaction was that whatever AI product recommended to pregnant women that they smoke cigarettes or put glue on pizza, likely it just struck me that like that's the kind of recommendation that you get from bad AI. The Antitrust Division is really an extraordinary institution. And I think that you can look back to other efforts to close offices, particularly during the Obama administration, and see how that just set back criminal enforcement by some estimates, generations. And so when I think about the Antitrust Division staff, I think about an extraordinary law firm of antitrust lawyers who could make a lot more money in the private sector, but choose to bring their talent and intellect and hard work to the public interest. And they do so for like, what, $150,000 a year in some of the most expensive cities in the country. And so on that score, I don't know why anyone would even like posit dismembering the Antitrust Division unless you're trying to do a really big favor to monopolies of all kinds. The San Francisco office has people who have PhDs in there's a French labor historian who's also an amazing lawyer. There's people who have PhDs in economics who are on the front lines of the most difficult tech issues. When we left on January 20th, Chicago was becoming a center of excellence for farming and food and agriculture. The Policy Shop was doing incredible work on merger guidelines and really just like syncing up our domestic and international policy. And so I know that the recommendations in that memo could not possibly have come from folks as thoughtful as Gail and Roger and the rest of their front office. And so it is my hope that every single recommendation about the Antitrust Division will be rejected. The staff deserves better and the country deserves better.
All right. I think we're getting the hook, but I don't want to cut off the... Oh, all right. I guess we will cut off the federal government, right? Remember that? Oh, I said I don't want to cut off the federal government.
Oh, I'll just say a couple quick things. I want to give a shout out to Eleanor Fox. So when I was a law student at NYU Law School, she was my antitrust professor. And so my first introduction to antitrust was Eleanor Fox. And I never told her this, but the reason I got an A in her class was because not only did I like take very careful, copious notes, I read all of her articles before the exam, and I just tried to copy what she said in all of her articles. And I think that's why I got an A. But in reading all of those articles, you know, I sort of got the bug, and I went and did my LLM in competition law at Edinburgh University. So I just want to give a shout out to her because, you know, the grand dame of antitrust. But yeah, we're fully aware of everything Doha has said, and actually we're benefiting from the mistakes the Obama administration made with the closings of those 4 offices and the retrospective on what happened with those offices. And so the good news is we're aligned on the goal and the objective and the need for like all of these attorneys and these economists and these paralegals. And so we know that it's necessary to achieve that. And Gail Slater is not an AI chatbot. And so, the second and third iterations are going to reflect her input. So
Thanks.